All right, sir. Lawyers are trained to recognize objectionable and unfavorable evidence and promptly object to their use. They're capable of presenting, as I mentioned, favorable sentencing information and attacking unfavorable sentencing information. In a jury trial, a lawyer will give an opening statement and make a closing argument, and they're capable of doing that very artfully. Have you ever had experience speaking in front of people?
I'm doing it right now.
Have you ever had experience speaking in front of a large group of people?
Yes, I have.
Okay, tell me about that.
I can't remember.
Okay,
I don't know how to articulate it, is what I actually mean.
well, you would articulate it by telling me what experience you have.
I've been in front of people where I've spoke to a group of people before,
How many people do you think were in that group?
at least 25 plus.
Okay, and how many?
It's a presentation.
How often have you had the opportunity to do that?
More than a handful of times.
How many is more than a handful? 6?
I have no idea. I cannot give you, that would be lying.
Okay. The other thing that a lawyer would do in a trial is help the court prepare jury instructions and select a jury. You understand how to select a jury?
Yes,
What would you do in that circumstance?
I would cross-examine them.
You would. Lawyers have the training, knowledge, and skill at properly preserving the record of a case for appeal. Have you ever been involved in an appeal?
No,
An attorney can also evaluate the strengths and weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement, which might result in a dismissal of some of the charges or a recommendation of a favorable sentence in return for your plea of guilty. This is an important part, and I would ask you to take note that you will, if you decide to not have an attorney, you'll not receive any special treatment with your defense. You'll have to follow all the same rules and procedures in your case as an attorney would have to. The state will have a competent attorney, and they'll have that advantage that an attorney represents for them. If you decide to represent yourself and the result turns out badly, you need to know that you will not be able to complain that you were ineffective as your own attorney in your defense. As I told you, you have a right to decide against having an attorney, but you must be aware that deciding not to have an attorney can turn out to be a very bad decision. Experienced lawyers almost would always decide to be represented by another lawyer in a criminal case. There are some of the things that you should consider before you appear at trial without an attorney, and I want to go through a little bit more now. Tell me more about your skills and knowledge that you have that you believe would be helpful in representing yourself.
where do you want me to begin? Ask me a question and I'll answer it.
I ask you a question, sir. What skills or knowledge do you have that would be helpful to you in this regard?
I'm able to learn quickly, and I know I can represent myself.
What's your college work? And you mentioned you had some college work.
Personal training as a personal trainer.
Okay, like in a gym or something like that? When you work in the gym, do you work with people, interact with people?
Yes, all the time. I did.
Do you still have that job?
No.
What other work have you done? What other career have you had?
I worked at a pharmaceutical company where I led teams. I developed drugs, and I was promoted multiple times as team leader to a supervisor.
To what degree did you lead people?
We led multi-million-dollar studies that had my name attached to those, to where I had a lot of responsibility, and I had to learn fast and move fast.
Have you ever studied criminal? Go ahead.
Well, I never was in the pharmaceutical company, so I learned fast, and I only had that job for 3 years, and I was able to propel myself that quickly with the little knowledge I had.
Have you ever studied criminal law?
I'm studying it now.
Have you ever studied criminal law previous to now?
No.
Have you ever had previous experience in the criminal justice system?
Yes.
What's the experience you've had in the criminal justice system?
When I was dealing with previous cases in the early 2000s.
Okay, tell me more about that.
I submitted to whatever the court told me to do. What do you mean?
What type of case were you involved with?
Drug cases.
Okay. And is that a case or cases where you were charged with crimes?
Yes.
And are those cases where you came to court?
What's that word mean? Caped, where they represented me?
I said came.
Oh, came, sorry.
Came to court? Did you have to come to court for those?
Yes, I did.
And did you have an attorney?
Yes, at that time.
Okay. Did you go to trial?
No.
So what was the result of the case?
I pled guilty to those charges.
Okay. Is that the limit of your experience in a criminal case?
Yes.
All right. You believe you're able to read a lot of information and
Yes.
digest a lot of information?
Yes.
What about your writing ability?
Yes.
Tell me more about your ability to write.
I wrote up all those. I wrote up all those notices. You didn't read them?
You wrote some documents and
Yes.
filed those with the court on two separate occasions.
Yes.
I struck both of those filings from the record because.
Yes. But that's the degree that I'm on.
Okay, so how did you compose those?
I wrote them.
And what did you use as reference?
Equitable law.
Okay, you understand this is not a court of equity?
You're telling me that that all courts are not with equity? No court in Indiana is equitable?
This is not an equitable proceeding here. Absolutely not. This is a proceeding at law.
Okay. Well, I represent myself under equitable law.
Well, we make I think, fine distinction in Indiana between what are equitable cases and what are cases at law. And this one most assuredly is a case at law. You're entitled to a jury trial. You understand that in an equitable case, you're not entitled to a jury trial? You understand that?
Yep.
You do?
You're telling me now.
Okay.
I'm learning as I go.
Okay. Anyway, so you, along that same vein, had filed some documents with the court. In those documents, you attempted to distinguish between your physical self and a capitalized corporate version of your name, not even your legal name. Do you understand that the court doesn't recognize that distinction?
No, I do not.
Okay. You understand that if you represent yourself, you'll be proceeding as the single legal entity named in the charging information, specifically Michael Corleone Allegretti.
That's not my name.
You understand that the court won't entertain any arguments to the contrary.
If that's what you're telling me.
Okay. Is that a yes or a no?
I understand that.
No. What I asked was whether or not you are aware that the court will not entertain arguments to the contrary. Your name is Michael Corleone Allegretti. That is your legal name.
That's not my legal name. I changed it.
Do you have documentation that you
Yes,
changed
I
your
do.
name? Please don't cut me
Oh,
off.
sorry.
Where did you get that documentation?
In Michigan.
In the state of Michigan?
Yes.
And you have a court order that changes your legal name?
Yes, I do.
Where's that documentation?
In my files. I had it in my possession yesterday.
Okay. Well, in this order today, will order you to provide the change of name
I will.
order from the state of Michigan to the court
I have no problem.
within, say, 10 days.
I can do it today.
And then, well, I'm going to give you 10 days.
Okay, thank you.
And then have you not changed your driver's license?
Not yet. I'm still in the process of doing everything.
When did you have the hearing that resulted in the name change?
I put it on my documents when I gave you the notice of intent. I put it on my documents then. Do you still have the copies?
How recently was it?
I don't remember the exact date.
Did you have to go to court in Michigan for it?
Yes.
You don't remember when it was?
I don't know the exact date, no.
Were these charges
I gave you all the documents, sir.
were these charges already filed at that time?
Yes.
You also, in those filings, suggested you're making a special appearance or that you do not consent to this court's jurisdiction. You understand that in a criminal proceeding, your personal consent to the court's jurisdiction is not legally required.
Say it again.
Do you understand that in a criminal proceeding in Indiana, your personal consent to the court's jurisdiction is not legally required?
No, I don't understand that.
Okay. Do you understand that the state of Indiana has jurisdiction over the charges filed against you, and this case will move forward regardless of whether you agree with that jurisdiction?
I don't understand that either.
Okay. You seem to be clever enough to understand these things. I asked you earlier whether or not you're suffering from a mental health condition. I predict that at a certain point, if you continue to suggest you don't understand simple terms, that your attorney will suggest to me that I need to have you evaluated for competency. Do you understand that that's a possibility here?
Nobody's speaking for me. He's not my legal representation.
Oh, he is. Do you believe that you are incompetent and incapable of proceeding on because of a mental incapacity?
No.
Do you believe you understand the players in the courtroom?
What players?
Do you believe you know what I do as the judge?
I believe you're an actor.
The other thing that you put in the record, you attempted to apply concepts like suretyship, subrogation, demands for accounting, and different things like that in these criminal charges. And as recently as a few minutes ago, insisted that you're dealing with an equitable case here. You understand that the Uniform Commercial Code, civil contract law, and commercial equity have absolutely no application in this criminal prosecution?
I'm just here to settle the matter and put my stuff on record that you already struck. How come we're going over it if you already struck it?
Sir, it's an important part of the Ferretta determination. I can't allow you to represent yourself if you can't answer affirmatively to these questions. And you've already not answered affirmatively to 2 out of the 4 that I have here that I want to make sure that we go through. You understand that?
No.
Okay. Well, what I said was, and I just want to make sure our record's clear, the UCC, civil contract law, commercial equity have no application in this criminal prosecution. And you understand that the only rules that apply here are the Indiana rules of criminal procedure, the Indiana trial rules as they're brought into those criminal procedure rules, Indiana rules of evidence, and substantive criminal laws of the state, along with various other administrative rules that we have to abide by, including our jury rules. You understand those are the only rules that apply in this case?
I understand now.
You do understand?
I understand what you just said.
Okay. And then I want to make sure you're clear. The United States Supreme Court has made it clear that the right of self-representation is not a license to abuse the dignity of the courtroom, nor is it a license to ignore the actual rules of procedure. Do you recognize that?
Yes.
You understand that if you are allowed to represent yourself, you'll be held, as I mentioned, to the exact same standards as a lawyer, as a licensed attorney.
Am I ready to talk? I'm sorry.
I'm just waiting on your response.
Oh, yeah. Yes.
And you understand that I will not permit you to waste the court's time or the jury's time by raising the theories that you've raised thus far, commercial law defenses, or challenging, say, the capitalization of your name, for example.
Do you want me to answer?
It was a question. You
Yes.
understand that?
Yeah.
And you understand that if you attempt to use your self-representation to file frivolous documents, disrupt proceedings, or refuse to follow rulings on issues, I'll find that you've forfeited your right to represent yourself and will appoint counsel to take over your defense.
Are you going to give me examples of frivolous? Because I won't know until I file them.
Well, the 2 attempts you've made to file documents previously were both deemed to be frivolous.
So should I just bring them to you directly and then you'll let me know?
I haven't made that ruling yet to require screening before filing, but it's on the horizon if you continue to file things that have nothing to do with the criminal case. Okay. So because you answered no to the first couple questions, you really aren't capable of representing yourself. And I do think that my ruling yesterday was correct. It seems that you're unable or unwilling to abide by the rules of procedure and substantive law, and I don't think that you can make a valid waiver of counsel. The court had spent some time yesterday afternoon reviewing a case, Hotep L v. State of Indiana, and I think that's an adequate Ferretta inquiry. Again, I think I must deny your request to proceed pro se. The court does not, well, I'll phrase it the opposite way. The court specifically finds the defendant's request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert these proceedings. Defendants utilizing the rhetoric of what is commonly referred to as the sovereign citizen movement, including raising nonsensical challenges to subject matter jurisdiction attempting to apply commercial law to a criminal prosecution. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based upon the filings that were previously stricken and the statements in open court today, court finds that the defendant's unwilling to comply with the rules of procedure and intends to use self-representation solely for the deliberate disruption of the proceedings. So I will deny the request to proceed pro se. I will maintain the appointment of counsel of Mr. Patton. And I think that will do it. We need to get some hearings. We need to get a hearing on the calendar.
I want to object to your ruling on the record.
So noted. Did you want to add anything to your objection?
I know I can represent myself.
And just like that, it's finished. After all the debates, the back and forth, and the confusion, the judge saw straight through it. This was never about understanding the law, it was about trying to dodge it. And that never works in court. In the end, he didn't lose because the system failed him. He lost because he chose not to follow it. Now he's left with a lawyer he didn't want and a situation that's only gotten more serious. The lesson here is simple. You can argue as much as you like, but in the courtroom, reality always comes out on top. If you enjoyed this, don't forget to like, subscribe, and stick around because the next case might be even more unbelievable.